Good morning. Good morning, everyone. My name is Alan Ingleson. I'm with the University of Calgary. I'd like to welcome you to the 4th Annual Environment in the Courtroom. As Dean Holloway's been called away at the last moment, we have taped his welcome message, which will start now.
Bonjour, je m'appelle Ian Holloway et je suis le doyen à la faculté de droit à l'Université de Calgary. Je suis désolé que je ne suis pas avec vous aujourd'hui, mais je suis très heureux de vous accueillir à la 4e conférence de développement professionnel sur le sujet de l'environnement dans les cours. Nous sommes particulièrement fiers de collaborer cette année avec l'Association du barreau canadien. J'aimerais donner mes sincères remerciements aux Environnement Canada et l'ABC pour leur générosité. Sans leur appui généreux, cet événement ne serait pas possible. Merci et bienvenue chez nous à la faculté de droit et bienvenue à Calgary. Hi, my name is Ian Holloway. I'm a law here at the University of Calgary. I'm very sorry that I'm not with you in person, but I want to welcome you to this, the 4th annual Professional Development Conference on the subject of the environment in the courts. We're particularly proud this year to be collaborating with the Canadian Bar Association. Their partnership has allowed us to take this program to a new level, and we're grateful to them. I want to offer my sincere thanks to Environment Canada and to the CBA for their generous support. Without it, this event simply wouldn't have been possible. Thank you. Welcome to the Faculty of Law, and welcome to Calgary.
And now I would like to turn this over to Stuart Chambers, who's the chair of the National... Well, that's good. I love it the way it starts. Okay, now I'd like to turn it over to Stuart Chambers.
Maybe just that in German.
Yeah.
Following on Dean Holloway's remarks, I would like to add my greetings on behalf of the CBA and the section which we affectionately refer to as NERLS. In addition to being the Institute Annual Symposium, these proceedings also constitute our, that is NERLS Annual Law Summit. And we're very excited to work together with the Institute to organize the symposium. Personally, as a litigator myself, I'm very excited to see a symposium devoted to evidentiary issues in the classroom. On behalf of the CBA and the section, I'd also like to add our thanks to Environment Canada for its generous financial support of this symposium. We'd also like to thank the Institute and the University for their support. As you noted, this is the first time we've partnered, and it's a great success. I'd also like to thank the numerous sponsors whose generous support has made it possible for you to enjoy the refreshments that will be provided throughout this symposium and the delegate kit bags. These sponsors are recognized on the front of the brochure. Last, and certainly not least, I do want to extend thanks and gratitude to the numerous hardworking CBA and university staff and volunteers who work so hard to make this symposium a reality. I'd like to single out CBA volunteer Jim McManamy, who's coordinated all of the sponsorships. I'd like to thank CBA staff Tina Etier for her hard work in putting this symposium together, and university staff Nancy Money and Sue Parsons. With that said, I realize none of you are here to listen to me talk, so I'm going to turn this over to our symposium co-chairs, Alan Ingleson from the faculty, and Sarah Powell and David Toronto, our past chair of NERLS. Thank you very much. Merci beaucoup.
Sarah, go ahead.
Thanks. Thank you for coming this morning, and it's going to be a great 2 days. I'm just going to get right to it with the details that you need to know how the day is going to work. First of all, we've posted everybody's bios, so we're not going to introduce people with in-depth explanations of their expertise. Many of you know them. We were just thrilled to have the crowd that we have out, so we're not going to go. You can find all of their bios on the website, so I'd invite you to go there. We talked about the sponsorship that Jennifer Danahy swung together, almost $25,000 to get you guys fed throughout the next 2 days, and we're very grateful for that. And I thought, the organizing committee thought that to express our gratitude, you might be willing to, if we send the hat around at lunch, throw in $5 or $10, and we'll send that money to the Alex, which is a community health center and food center in Calgary. They do great work. If you'd prefer to donate online, it's thealex.ca, and so we'd invite and encourage you all to do that, to express our gratitude, not only to the University of Calgary, but to all our sponsors. So there is no such thing as a free lunch, and so that will make that even. Bathrooms are just out the door. They're in the immediate, so if you're lost, you can just ask, but I think the women's are to the left and the men's are to the right.
That is correct.
Or the other way around, so you'll find them. Lunch today is fully sponsored. It's just a 3-minute walk away. We can have a parade over so everybody gets there, but if you're familiar with Calgary, it's at McEwen Hall. Everybody's nodding. So I walked over there. It literally takes us a few minutes, so hope you'll join. After today, we've got a reception in the atrium over at the administration building. It's a great facility, and it'll be a fun reception, so we hope you'll stay for a drink before you have to head out. I think that's all I was going to touch on, and I'll turn it over to Alan. Was there anything else we wanted to say?
That's everything.
Good.
Thank
you,
you.
and enjoy the morning.
Okay, I'd now like to turn this over to Peter Rajinski, who's with the Special Prosecutions Office here in Calgary. Peter's a former classmate of mine, an avid outdoorsman. This isn't in the bio, an all-around great guy. Peter.
All right, thanks very much. I guess I should probably stand up close to some microphones so that everybody can hear me. Just so you kind of know a little bit more about me, I'm with the Alberta Crown Prosecution Service. I've been a prosecutor for 15 years or so, and I've been doing environmental prosecutions almost exclusively for probably the past 8 years. I'm one of a team of 2 in Alberta, my colleague in Edmonton, and I'm part of specialized prosecutions. We have a regulatory unit where we do occupational health and safety and environmental prosecutions. So I guess the first thing I should point out is that I'm not Rex Murphy. The second thing is that, the format, and I think the CBA format is maybe a little bit different. One thing that I did in preparing this presentation is I just emailed around and got information from various prosecutors across the country, and so I've prepared a bit of a presentation on some of the things that they've brought to my attention. So hopefully I'll be able to get through that, and then we'll have time for questions and a discussion at the end. I went to law school. I have a disclaimer. So the views are those of me and not those of Alberta Justice, Solicitor General, Alberta Environment, Sustainable Resource Development, or Government of Alberta. This is for educational purposes, not a policy document. I have to stand close to the mic. I definitely got some help from different prosecutors across the country, from Public Prosecution Service of Canada and a number of the prosecutors that do environmental prosecutions. So the things I'm going to talk about briefly, I'm going to talk about some cases and legislative developments from the last couple of years. I'm also going to talk about some cases that are not just from the Court of Appeal or the Court of Queen's Bench or the Superior Courts. One of the things that's a bit unique about environmental prosecutions, and I suppose regulatory prosecutions generally, is that provincial court decisions generally punch above their weight. There's just not that many appellate decisions. My experience appearing before the provincial courts is that judges are quite often interested in these cases. It's a bit of a change from the usual criminal dockets that they deal with, and we don't always agree with the results that we get, but we often get interesting and thoughtful decisions. So I've got some cases from the provincial courts. So And then instead of just doing a little drive across the country, I've broken this up a little bit by themes. I'll talk a little bit of penalties. I've got a couple of search and seizure cases that might be of interest. I talk a little bit about the contravention of administrative orders. This is something that comes up in the prosecutions world periodically. I'll talk a little bit about reporting and the big case from the Supreme Court of Canada. Creative sentencing is another theme that recurs pretty regularly in our environmental prosecutions world. And given that we are in Alberta, I'll talk a little bit about a few Alberta cases, and I'll try to avoid the hardball questions from some of the Alberta Council here. So I'm going to start off talking about penalties, and anecdotally I can tell you that I keep hearing periodically about something called penalty creep. And the thought is that penalties seem to be increasing, notwithstanding the fact that the maximum penalties haven't increased for similar contraventions. And I don't have any empirical evidence that this occurs, but I think it's quite possible. And one of the big reasons is, and particularly in Alberta, we have a case that talks about how the size of the enterprise or the financial resources of the offender are a relevant factor for sentencing. And what I've observed over the years is that the size of these corporations is increasing. So what 10 years ago would have been a $5 to $10 million corporation is now a $50 million corporation. And I think this potentially accounts for some of this penalty creep. The other factor that I think is pretty significant is when the ceiling rises. And so in November 2013, the Federal Fisheries Act received some substantial amendments. And one of the big changes was the maximum penalties. So these came into effect November 2013. Now we're probably getting to the point where prosecutions that are coming before the courts are going to be within the new penalty regime. And so the penalties have become fairly significant. So for individuals, the maximum penalty is up to $2 million in terms of a fine. For corporations, up to $12 million. One of the things that is kind of unique is this concept of a small revenue corporation. So there's a special penalty, maximum penalty for smaller corporations. There's a subsequent offense premium, which is something that is happening. I think even in some of our provincial enactments, we have subsequent offense premiums. So if you get convicted again for doing the same thing, the maximum penalty goes up, and there's also now minimum sentences. There's been a couple of cases, and one very recent case that is a pretty significant penalty under the Fisheries Act. I don't have too much information on this. It's fairly new. It's from Quebec. It's in French, and I don't have access to the actual decision. But this is Regina and Bloom Lake General Partner Ltd. So this was 45 counts under the Fisheries Act. And one of the counts, or some of the counts, dealt with a tailings pond dam release. And the total penalty was $7.5 million. And I'm guessing this was under the old Fisheries Act penalty regime. So I'm guessing that this is probably the high watermark up to this point for an environmental penalty. It's a pretty substantial penalty. Someone brought to my attention another case. This is from New Brunswick, Regina and Kelly Cove Salmon Ltd. I guess I'm pretty sure it's unreported. It's from New Brunswick from April of 2013. And I gather the facts were something along the lines of a fish farm illegally used a pesticide to deal with some sea lice issues, and sadly that pesticide also kills lobsters. So they were convicted, and again, this would have been under the old penalty regime under the Fisheries Act, and they were subject to a $500,000 penalty. we've also had a recent case in Alberta. That's actually two separate prosecutions, same company. And these were prosecutions under, this one was just under the Provincial Environmental Protection Enhancement Act, but there's another prosecution under the under APIA and the Federal Fisheries Act. So Plains Midstream Canada is basically a pipeline company. They had two pipeline releases, one from April of 2011. It was 4,500 cubic meters of crude oil. It was released into Muskeg. There was an Aboriginal community up there that was somewhat impacted, but generally it's a pretty unpopulated area, relatively speaking. Basically, the company kept ignoring alarms and restarted the pipeline, resulting in a pretty significant release. And they pled guilty under Section 112 of our Environmental Protection Enhancement Act, which is basically failure to remediate. That section puts an obligation on a person who releases a substance that causes an adverse effect to the environment. They have to, as soon as they knew or ought to have known, they have an obligation to start taking steps to minimize the release and to mitigate the effect. So they pled guilty to failing to respond and were subject to a $450,000 penalty. The maximum under legislation was $500,000. About a year later, they had another release of about 460 cubic meters of crude oil into the Red Deer River. So this happened closer to central southern Alberta. Again, the company ignored signs of a pipeline failure, and the leak was actually identified by another company that was flying over in a helicopter. It was released into the Red Deer River, which was flowing pretty strongly at the time. Lots more people around. There was definitely significant environmental effects downstream and effects on property. So they ended up pleading guilty under the Fisheries Act of failing to report the release, and were subject to a $400,000 penalty, and under the Environmental Protection Enhancement Act for failing to report the release. And again, it was a $450,000 penalty. So those were pretty significant penalties in Alberta. I don't think they're the largest global penalties, but they're fairly recent and fairly big. Sorry? I'm pretty sure that, so we have creative sentencing provisions in our Environmental Protection Enhancement Act in Alberta. So a portion of the provincial penalty went to creative sentencing projects, and then a portion of the penalty under the Fisheries Act did go to the Environmental Damages Fund. I'm not sure exactly what the proportion was, but it was my colleague's file, but I'm pretty sure a portion went. Let me talk very briefly about search and seizure. And they use search and seizure because that's kind of the criminal way of talking about it. I think the regulatory way of talking about it is inspection. Yeah, inspection, investigation, all that, all those magic words. I've got a case that, it's an Alberta case. I mentioned it to one of my federal colleagues from another province, and it wasn't a well-known case, but it's kind of an interesting case on the facts. So it's a case of Regina and Deep, Alberta Court of Appeal from 2005. And so Mr. Deep was a fish farmer. And as one of the federal crowns mentioned to me, fish farms on the prairie, who knew? So Mr. Deep was licensed to farm a tasty, nutritious fish known as tilapia. But the two conservation officers had some information that he was actually growing bigmouth buffalo fish, which was not a good thing. So anyway, so they went to his property. There's a bunch of Quonsets. They're doing an inspection under the Provincial Fisheries Act. And they actually found some bigmouth buffalo fish, so he was in contravention of his license. And there was Quonset that they'd seen him lock up, but strangely enough, when they wanted him to open it up for the inspection, he didn't have a key. So the conservation officers left and then thought about it some more and decided to come back with a locksmith and, under their powers under the Act, compel him to open this so they could see if there's buffalo fish in there. Well, miraculously, just before the locksmith started work on the lock, Mr. Deep came up with the key, and lo and behold, there was a grow-op in there. So the whole case was really about the drugs, not the fish. And of course, Mr. Deep argued through his counsel that when the conservation officers discovered the contravention, they lost their regulatory inspection powers. They had a basis for laying a charge. And our Court of Appeal basically said no. And there's a little brief discussion about the Jarvis and Ling cases. And I think the big thing that comes out of this, and it's consistent with the case law that I've seen, is that the courts generally see a very limited privacy interest in licensed activities and regulated activities. So another case that somebody sent to me, a 2013 case from the Nova Scotia Court of Appeal, Regina and Hicks. And in this case, Mr. Hicks was alleged to have been burning some garbage in a barrel outside his house. And when the provincial inspector showed up to see what was going on, she saw a burning barrel, or wasn't burning, she saw a barrel in his yard outside his house. And of course, Mr. Hicks got into a confrontation and the inspector decided to leave. So Mr. Hicks was charged with obstructing the officer. And he was acquitted at trial because the judge found that his yard surrounding his house was a private dwelling place. And so the officer couldn't go there to do her inspection. And so the Crown appealed to the Summary Conviction Appeals Court, and again, the acquittal was upheld. And, kudos to the Crown for persisting. They took it to the Court of Appeal. And the Court of Appeal decided, yeah, we'll hear this case. And they decided that, I think the Court of Appeal used it more to admonish the lower courts for their lack of skill in statutory interpretation, but there's a great quote from it, and it goes something like this, it's from paragraph 42. There are all kinds of yards, backyards, front yards, barnyards, scrap yards, freight yards, shipyards, to name a few. These are the places one is likely to find the kinds of things or substances which are meant to fall under the scrutiny and surveillance of the Act. Yet by any objective standards, such locales would hardly be considered a dwelling place. So that was pretty much the end of that. I'm going to talk a little bit about contravention of administrative orders. So in a prosecutor's world, prosecuting for failing to comply with an administrative order should be a bit of a no-brainer. There should be a fairly explicit and prescriptive order, and there should be a pretty clear breach of it, and you just hand up the order. This was the order. This was served on this guy, and he failed to comply. But when someone can launch a collateral attack on the order itself, the reasonableness or the validity, that makes things highly complicated. So this case was sent to me from Saskatchewan, Regina and EnviroGun Ltd, 2013 case. So EnviroGun was operating a hazardous waste disposal facility, and I gather that under the Saskatchewan legislation, before they issue a remedial order, they give a notice to someone saying, hey, we're going to issue this remedial order. Do you have anything to say about this? And no response, so the environmental protection order issued. Subsequently, this company decided to try and take this to the court, but the court's jurisdiction was limited to issues of law or jurisdiction. They say there's no issue for us to consider. So the application to have the order reviewed in the courts was dismissed. And of course, they failed to comply. And so the company at trial attempted to attack a collateral attack on the order, saying the order itself was unreasonable, and so they didn't have to comply with it. And that was rejected. And it didn't strike me as being a particularly robust process for reviewing the order. It was relatively informal, but that was enough to be fatal to the collateral attack on the order in the prosecution. So I think someone who's subject of a remedial order who doesn't complain about it if they have a problem with it is going to be fatal to any, is likely to be fatal to an application to attack the order at trial. Talk briefly about reporting. Reporting is one of my pillars in terms of our regulatory system that is pretty common throughout Canada. You know, we have these sort of these foundational pieces. You know, one is do no harm. The second one really is it's much better to ask for permission than forgiveness. And the third and fourths are you must report, and when you report, you must report accurately. And this is something that's not really known to the criminal law. In the criminal law, you don't have to report yourself, but in the regulatory sphere, you often do have to snitch on yourself. So this is a case, and this is kind of a biggie. This is Supreme Court of Canada from 2013. It's a case out of Ontario, Castonguay Blasting Ltd. And basically, the offender was blasting, and the fly rock landed in a house and caused some damage. So they reported it to the ministry they were working for. They reported it to the Ministry of Labour on the OHS side, but they didn't tell the Ministry of the Environment. And so they were charged with failing to report an adverse effect. And at the Supreme Court of Canada, the company argued for a very narrow interpretation of the triggering requirements for reporting under the Ontario environmental legislation. And that narrow interpretation was pretty vigorously rejected by the court. And there's some, I think, interesting comments in there. And one is that the case reinforces this idea that the purpose of reporting is so that the regulator decides what's going to happen next. It's up to the regulator to determine what the next response is, and so timely reporting is really important. And I know we've had some cases locally where, you know, companies have said, well, you know, we can do a little bit of investigation before we have to report it. And I think that Castonguay Blasting definitely limits that, the scope of the investigation a company can do. I think once they met the triggering requirements, they got a report. And I think the other thing that Castonguay Blasting does is it talks about an endorsement of a very broad and purposive interpretation of environmental legislation. There's a question about creative sentencing. This is a case that didn't go terribly well for the Crown. So there was a fire at a regulated landfill, and it was a pretty big fire. This is a 2014 case from the British Columbia Court of Appeal, Regina and Ambrosi. Fire at a landfill, and the local city had to respond to put out the fire, and they spent quite a bit of money doing it. So the company was convicted and fined, and then they were ordered to pay restitution to the city for the cost of the firefight. And most of these creative sentencing provisions, and this is common throughout provincial and probably federal legislation as well, is, you know, they've got clauses that allow a court to prohibit people from doing things. There's usually a restitution clause for government action, such as the Environment Ministry having to clean up a site and so on. And government is usually referred to as whoever the regulator is, and publication orders and so on. And there's usually a catch-all phrase at the bottom that says anything else to secure the good conduct of the offender. Well, of course, the order for restitution to the city was under this last catch-all phrase, to secure good conduct of the offender. In the Court of Appeal, the offender appealed this, and the Court of Appeal basically said no. And it's interesting because we've done this in Alberta. Fortunately, it's a BC case, but the court said that if the legislature's intention was to order restitution, they would do it explicitly. So that may limit the application or the use of that provision to get restitution orders. I talk just very briefly about some Alberta cases. One of the themes we've had for the last couple of years probably is pipelines. I talked to you about Plains Midstream. We've also had a couple of other recent cases. SEMCAMS, Regina and SEMCAMS, ULC, a 2013 case, and Regina and Sinopec Daylight Energy Ltd, a 2014 case. These are both joint prosecutions with the PPSC under the Fisheries Act and the Environmental Protection Enhancement Act, and they both happened in Fox Creek, Alberta, same place, different times. And they both involved releases of process water. So process water, if you drill deep enough underground, the water you get isn't fresh water anymore, it's salt water. So it was a release of salt water, one into a wetland complex and one into ice-covered tributary of the Athabasca River. Both are guilty pleas under the Fisheries Act and the Environmental Protection Enhancement Act. And the penalties were pretty similar, $350,000 as a global penalty on SEMCAMS and $380,000 as a global penalty on Sinopec, and that was broken up between fines and creative sentencing orders. Other big news in Alberta has been REDA, the Responsible Energy Development Act. So I think most of it's been proclaimed by now. The world before was that the Energy Resources Conservation Board looked after licensing and safety and economic development of the oil and gas resources, and the Alberta Environment Sustainable Resource Development looked after the regulation of the environment side. And what's happened now is that all of the environmental piece has now been transferred to the Alberta Energy Regulator, so that's a fairly new development. And the last thing I'm going to finish off with a little case here. One of the things that happens in Alberta is there's cases that don't involve pipelines as well. So this was kind of a fun little file that we ran a trial in Red Deer this summer. I can't say that I was really looking forward to spending 2 weeks in July in Red Deer this summer, but it was actually pretty nice. I really enjoyed it. And this was a file that was started by my then colleague Susan McCrory, who's going to be presenting a little later today. So I took it over after Susan retired. So this is a little piece of land north of Red Deer. You can see that there's I got a pointer here, but you can see there's a line of buildings on the horizon. So this is a company who's developing a bit of an industrial park. And so they had some buildings on it, but they hadn't developed the northern portion of this land. And their business model was they would lease little portions of this land, and the lessee would do all the leasehold improvements. And then when the lessee either went out of business or the lease ended, the owner would take it over. So they had a stormwater management plan for the one portion, but it didn't extend to the northern portion. And as most of you probably know, when you strip all the soil and reshape land and stuff, you got to think of what to do with the stormwater. But unfortunately, this is a closely held company, so Mr. Veenstra, who was the principal of the company, thought he knew how to do this, so he was telling these guys how to shape the land. And you can see there's a bunch of excavation work that's done in here. He's told them where to shape it, and he told them to dig a little retention pond in a corner of the property. And the problem is there's no outlet for the water from this part of the property. And the second problem was that it started to rain and rain and rain and rain and rain. And as you can see, there's all kinds of water accumulating. So and I should back up a little bit. So Mr. Veenstra had previously applied for a temporary diversion license to pump water that had accumulated. This was a few years previously, so he kind of knew that you need permission to pump water, especially onto somebody else's land. But when his lessee's employees were asking, so what do we do with this water? He said, well, just pump it across the road. So they didn't know any better. They thought, well, he's a wealthy landowner. He probably knows what he's doing, so sure, we'll start pumping. So they pumped and they pumped and they pumped and they pumped and they pumped it across the road. And of course, across the road was a big hayfield. So how much harm could this possibly do in a hayfield? Well, there was a hayfield, and then there was about a 25-meter treat escarpment, and there was another little field, and then there was the Red Deer River. So what ended up happening was this stuff all ran down to the Red Deer River, and it caused a bit of a landslide on this escarpment. So he ended up with a little bit of a mess. So Mr. Veenstra was charged, and the company was charged under the Water Act for an activity without an approval. And he was also charged with releasing a substance into the environment that caused a significant adverse effect, to wit, water. So it's quite an interesting little file. A couple of the issues was, one was that the actual activity and the release was by the lessee. So Mr. Veenstra and his company didn't actually release the stuff. But the trial judge found that Mr. Veenstra had exercised enough control and was therefore culpable. So he was convicted in his personal capacity, and the company was also convicted. The other issue, of course, was that defense argued that the substance definition should be restricted to pollutants, things that are actually kind of poisonous or toxic in some way. And of course, we didn't take that view. And I think that the definition of substance in our act is extremely broad, and that was accepted by the court. So he was convicted of both the release of the substance and an activity without an approval. It's a closely held corporation, a penalty of $80,000 for the corporation and $15,000 for Mr. Veenstra. So that was kind of a unique application of a substance release provision, and that was all Susan's idea, so she gets most of the credit for it. So I don't know how we're doing for time. I'll leave it up to the, I can probably answer some questions, or.
We have 2 minutes for questions, so let's take it. Questions?
Oh, another question. All right, sure.
Can you talk about fines and how bigger a corporation is?
Yeah.
If the entity that's being prosecuted is another government organization
Yeah.
that is large and has significant resources, but its resources are actually coming from tax dollars, do you think that the case law reflects this recognition that if one government entity pursuing another, ultimately the same stream of revenue that's coming in? So an example would be if Environment Canada was prosecuting a municipality.
So,
Can I interrupt 1 second?
Yep.
Can you repeat the question, because there's 160 people listening on webinar and they can't hear what you're saying.
all right, I'll do that. So the question is, relates to prosecution of another branch of government, and how that, and I'm paraphrasing a little bit, but how that affects the penalty that that gets issued. And I can speak from sort of Alberta's experience. Historically, we've had a couple of prosecutions of municipalities. So we prosecuted the city of Calgary, and in those particular cases, the penalty was still fairly significant, but pretty much all of it went to some creative sentencing project, so either some sort of a compliance system or something like that. So it wasn't sort of a wealth transfer from the government, or from the municipal government to the provincial government. I can't speak for other jurisdictions, but that's our experience in Alberta, is we've generally not sought a regular fine. It's been pretty much all creative sentencing ordered.
Are there any other questions? Well, thank you then, Peter, for the great overview of what's happening in terms of prosecutions across Canada.
Thanks very much.
Thank you. Then if I can introduce our next panel to come up, Science Primer for Environmental Prosecutions and Hearings, What You Need to Know, But We're Afraid to Ask. And I'm delighted to have Susan McCrory, Dr. Deeb Burkholz, and Dr. Dan Bummer to handle this panel, so we'll take it away. Susan.
Good morning, and I'm sorry I've got a miserable cold, so I'll try not to sniffle too much. I know the title of this presentation is Science Primer for Environmental Prosecutions, but I think the better description of the topic would be how science crashes and burns in the courtroom. And what you have before you is some very elderly practitioners. I got 30 years under my belt. Deeb, I'm afraid, has even more. We're kind of guessing that maybe between the three of us, 25 years. We're talking 100 years here. It's sort of bad. And I, fortunately, am now retired, so unlike Peter, I don't have to be polite. I don't have to get permission from anyone. And so my sort of pitch to you all is that science in the environmental courtroom sucks. It doesn't work. And this is hardly new. I did a little bit of homework, and apparently the first reported case on using expert witnesses in the States was in a witchcraft trial in about 1700. And about 50 years later, they were whining about the problem between science and law in one of the early law journals. So this is not exactly new stuff. What we're going to do is whine a little bit, and then we're going to go in reverse. I get to whine first, ladies first, and then Deeb, and then Dan. Then we're going to back her up and say, are there solutions here? I mean, we've been kicking around this problem for a long, long time. And there's some very smart people who've come up with some solutions, and I think we've got some smart people here that we can get some solutions. And let's do something about it. Let's stop just whining about it. But I say, I get to whine first. I got to tell you, in the 20 years that I was doing exclusively environmental prosecutions, I have 3 observations, or perhaps 4 observations to make. Judges don't get it. They try to avoid a scientific issue as best they can. They'll come up with, they'll say it's credibility, they'll say it's statutory interpretation. And my other observation is, for the most part, if the science is not consistent with their worldview of things, they ain't gonna buy it. I don't care how fancy the expert is on the other side. So this has been a discouraging thing from my point of view. I'm so glad Peter ran that last case, the Veenstra, because every time I've run a case on significant adverse effect, I've lost. So there's something awry here. Now, I get it. Judges have, they're the ultimate decision makers. We have to meet the standard of 91% or more on the criminal side of the fence. And so there's good reasons for judges not to accept the science because they're so skeptical. But surely there is something we can do. Surely there are new ways of looking at this, that we can bring good science into the courtroom and have it well accepted. And I think we're at a crisis right now because of the horrendous case of Dr. Smith from Ontario. I think many of you will know about that. Dr. Smith was a pathologist at the Hospital for Sick Children and botched about 40 or so autopsies, resulting in 12 findings of guilt before the court, wrongfully so, one in which a young man was sent to jail for, I think, 14 years before he was exonerated. So I think we are in a position right now that if the courts were skeptical before, they're monstrously skeptical now. And again, whose fault is that? When a judge doesn't understand, it's the Crown's fault. But we've been trying for 20 years to rectify that, and our efforts have been, for the most part, unsuccessful. So that's my whining. I'll let Deeb whine, and then, as they say, we'll come back the other way with, we hope, some solutions. And we're turning to you folks for inspiration as well.
Thanks, Susan. I've given a lot of expert testimony, probably too much in my life. Most of it environmental offenses, but I've also been involved in a couple of criminal cases. In my view in life has always been, if you do things right, then nothing can go wrong. In other words, if you use forensic procedures, peer-reviewed procedures, have operating procedures, chain of custody, everything will be fine, and the case will be turn out the way that you would hope it would be. I mean, we're always in the dark as an expert witness. We're asked to give evidence in a very small area, really not realizing what the whole scope of the case is. But we do things properly, because my agenda has always been is that the matter will get settled in discovery. Trial will not be necessary. There will be no weakness in the evidence that we give. And if we do go to court and we are challenged, whether we're working for the prosecution or defense, we would hope that the procedures that we followed would be scientifically sound and our testimony would be credible. This is kind of a naive view that I've learned the hard way, is that your testimony will make a difference. Oftentimes it doesn't. The reality check is this may not be the case. Case law, or like Susan said, some other factors may determine the outcome of a case, and your testimony may have been totally useless. And as a professional, it's hard to stomach, because you really don't know what's going on, and you really don't understand what the decisions are based upon, right? All we know, we've been asked to do a job, and we do it to the best of our ability. But I've done cases, and I've only got 5 minutes or less, where the case was dead right from the beginning. You know, it was a charter breach, and I think Susan remembers that. So the question is, why did I even bother coming to court and wasting the court's time? But I've also been in cases where science has been important. You present your case, and then the other side presents their case. And in some cases, you might be surprised the judge will even ask you, well, why don't you review their work? And you do that, and you come to the conclusion, well, you know, every fundamental of science has been violated here. This is really, really poor science. And yet they win the case, right? And it's hard not to take it personally. But then again, you realize with experience that the evidence that was presented, you know, may have been totally irrelevant to the decision. So, very timely, National Geographic came up with an article this March. Why do many reasonable people doubt science? And the statements were revealing. We live in an age when all kinds of scientific knowledge, from climate change, vaccinations, fluoridation, faces furious opposition. And some even have doubts about the moon landing. And then Susan talked about the Charles Smith case, the Annie Dukeman faking results, drug tests, 34,000 individuals were impacted. And crime labs in the United States gone under scrutiny and basically suspended, again resulting in people being sentenced, you know, improperly. And I guess this is what basically touches on what Susan is saying, is when you're dealing with a very, very complicated case, you're dealing with a case that's very, very complicated from a technical point of view. You know, how does the judiciary make a decision? Well, a lot of it, you know, is through peer review. Does this science make sense? What would my colleagues think? You know, is this rational? And I mean, you know, that's not unexpected. You know, as Susan was saying, that it may have a large bearing on what a judge decides. And the other thing that's really bad about scientists, we change our mind. You know, if information comes forward that allows us to reevaluate, we're quick to reevaluate, and of course that has credibility issues. So sometimes, it's my last one here, sometimes our evidence is very important. Communication is a huge issue. And you can, I'm not trying to be cute here, but these are some of the tools that we need. We need to pay attention, you know, to our audience, and oftentimes it's not that the science is poor, our communication is very poor. And this is the last one here. Sometimes our opinion is not accepted or redundant. And the reason that it's not accepted may have nothing to do with the science. It may have something entirely to do with case law. But I've been in a lot of cases where I've given expert testimony only to come up in another case and have, you know, a lawyer, either prosecution or defense, basically challenge my credibility. And you really have no recourse to defend yourself. In science you do. If I publish a paper and it gets accepted, there may be 1 million people out there that hate what I'm saying. And they can go and protest, but then I have the right to rebuttal. Well, you don't have a right to rebuttal in the system that we have here right now. And that's fundamentally wrong. And I would believe, I presume that there are experts out there that are tainted through no fault of their own, and they really did nothing wrong and basically did good science. Too long. It's 5 minutes.
Oh God, what the heck? Okay,
Dan, brother, third one down.
thank you.
Good morning. I'm pleased to be here. Thank you to CBA and University of Calgary for the invitation to speak to you. My name is Dan Bunner. I'm a principal in Environ. We're a very quiet 12,500 person firm. You probably don't know who we are. We've got 300 offices worldwide. Our annual revenues are about $1.7 billion. About 20 to 30% of our revenue involves legal counsel. Many of the law firms attending here I've recommended because I quite strongly believe in quid pro quo, and I've worked for many of you in the past. My exposure to litigation support comes primarily from civil proceedings and hearings. Thus, my observations and perspectives are somewhat different than my co-panelists. I'm a geologist. I'm not a lawyer, and I am not a litigator. In some instances, I find my observations today naive and purposely provocative to generate discussion. Nonetheless, I think my observations may be constructive because they may give you a sense of what the public thinks about legal matters which you argue and how they are fairly or unfairly decided. As my first naive perspective, I'd like to offer to you that I would have found it very difficult to be the son of a litigator. Many of the best litigators I've worked for are extremely smart, thick-skinned and tenacious individuals in the courtroom. In a parenting setting, it must be hard to turn those personality traits off. I'm not sure if I would have liked my parents to be conniving, pugnacious, argumentative SOBs. In the courtroom, science can be conveyed in an overly complicated way. Often, I think I went the wrong way. There we go. Often, it obfuscates what are essentially easy matters. If evidence is given by an expert, the expert needs to learn how to communicate simple ideas at a grade 6 level without sounding paternalistic. Further, lending weight towards greater acceptance of the same evidence from perceived authoritative experts should be eliminated. In decisions, I note that judges seem to fall back on precedent legal arguments rather than cite specific facts. As a layman, this appears to me to be the easy way out. Preparing a decision that has less of a chance of being appealed and or worse is subsequently found to be an error in the application of law has the ability to make the author, the judge, of the decision look bad. To me, this induces a very strong incentive for judges to consider precedent with much greater weight than science. Remember, if I make an error, I get sued. If a judge makes an error, we just get a new trial. Decisions increasingly appear to be based on tangential interpretations of the intent of definitions of provisions within regulatory statutes. Further, those interpretations somehow change over time. I ask you, how? Why does the intent of the law change over time? In my limited opinion, one of the most outrageous examples occurred in Smith versus Inco, where the concept of that of a smelter polluting a person's property was considered by the court to be not a non-native activity. How was this possible? Don't get me wrong, I've read and reread the judgment and understand the logic that was used in the case. However, to me, the ruling is similar to the following equally outrageous logic. Guns are manufactured to kill something. If the gun is used for its intended purpose and a person is killed, is this not a non-native activity? By extension, the polluter, or in this case the killer, is not responsible. Remember, I'm part of the public, not the legal profession. Just think how the public viewed this decision. We, the public, can be extremely cynical. I've cribbed and distilled this slide from a presentation by Diane Sachs, which she gave at the Ontario Bar Association conference in 2015. I tend to agree with the synopsis that Diane presented. I have the opinion that the case file precedent has established a creeping change in the interpretation of the original intent of the law, such that negligence, nuisance, trespass, and Ryland's claims are being castrated. If you agree, then how will plaintiffs who have been harmed be made whole? A significant amount of time is spent strategizing for mediation hearings. A great deal of effort goes into drafting expert reports for mediation. These reports are almost exclusively based on science. My understanding is that mediation hearings are intended to inhibit court time and costs, essentially to see if an agreement can be reached before trial. In my observation, this is very, very rarely the case. I perceive more time in positioning a claim and declarations of who has right on their side. God is on my side. As a result, I perceive more time in positioning claim. Mediation hearings are also without prejudice. As a result, the mediation process can subtly, systemically coerce science experts to behave more like advocates. That's a fact. I don't like it, but it happens. At this stage in a claim's life, technical agreement is very difficult to achieve. Remember, geology and hydrogeology, often the underpinnings of a pollution claim, are inexact sciences. People want 100% from me. They're not going to get it. They are interpretive sciences that usually can only provide an opinion. Differing opinions are no more right or wrong, so why agree in a mediation hearing? Appeals of regulatory orders are becoming much harder to achieve. Federal, provincial, and municipal governments are operating with financial deficits. Staff levels at regulators are diminishing. Knowledge at the regulators is being lost. They do not have money, time, or understanding to remediate pollution caused by private parties. Further, public opinion is saying polluters must pay, not my tax dollars. As a result, I perceive that political policy has shifted to the point that anyone who may be able to pay, and then some, are now being named in orders, and those orders are becoming more difficult to rescind or modify. I have family members in both the PMO's office and in the Premier's office, and I hear this on a regular basis. Previously, much more pre-order issuance negotiation was conducted. Science was often accepted by the regulator to decide who or what was included in an order. We used to negotiate. However, recently there appears to be a trend for regulators to enforce strict interpretations of statutes rather than consider science at the order stage. I recently listened to a regulator retort to a client, which is a pass-through property. If you don't like being named in the order, take it up at the environmental tribunal. Imagine the anger of the client who's a harmed party being told you are in part or in whole responsible. Kawartha Lakes, here we come. At environmental tribunal hearings, science shines. This appears to be the case because appellant challenges in the scope of hearings often revolve around science issues. Rulings tend to contain significant reference to science evidence. Appellants tend to be individuals or small groups opposed to a project, for example, a wind farm. Unfortunately, appellants generally lack funding and hence are inhibited from hiring experts. Much of their testimony is heartfelt, but not accepted by the tribunal. In many instances, the requirements of a project approval is prescriptive, having been established via a political process long before a hearing occurs. As a result, if a proponent follows the approval process, the chances of an appellant winning at the Environmental Review Tribunal are very low. The public has indicated to me that they feel the process does not favor appellants. I had a lawyer look at this. The actual words they used were rigged. To date, they realize that they are often up against the government with unlimited resources and not just a proponent. They do not understand why the hearings are narrowly scoped or why the tribunal will not consider broader arguments and the submission of non-scope evidence. Board of negotiation hearings seem similar to mediation hearings. Science is used more on the advocacy basis. However, the knowledge base of the boards is limited, and many negotiation hearings only end up referring to the matter to the municipal board. It's generally a waste of time. Where property explosions are at issue, I find municipalities are trying and acting like opportunistic sharks. It angers me that a municipality would try to lessen the fair compensation value of a property using contamination as a lever. In most jurisdictions, there's no requirement to remediate a property if it is to continue to be used as it already is. If a property owner does not want to sell, why should they be further penalized over and above the penalization of expropriation? Just because a municipal policy is being established that indicates the municipality will not accept a conveyance of contaminated land. At the municipal board hearings I've noted that the boards are extremely reluctant to consider issues other than traffic, noise, and other planning aspects. I've attended hearings where the board has agreed to hear science-related environmental issues only to have the chairperson explicitly state in their ruling that the board does not consider environmental issues with the same weight as traffic and noise. In one instance, I was on the stand for 16 hours. My client's singular reason for being in front of the MB was dismissed with one non-technical sentence. In my opinion, these types of boards are unprepared to hear many science-based issues. Thinking outside the box. Do you want me to go into that?
Absolutely. This is the important part. You've heard the whining, okay? We're unhappy. Go. What are your top 3 recommendations?
All right. Thinking outside the box, what would I suggest as alternatives to our current way of hearing science evidence? Use mandatory single experts. Have experts produce concurrent expert evidence. Perhaps. But I do not favor the single experts model because no man or no woman is an island. We experts do not know all. Different interpretations and opinions may be equally valid. With respect to concurrent evidence, I think that the practice of hot tubbing consultants very rarely leads to full consensus. Usually I end up arguing, and sometimes the other consultants who aren't used to this are extremely unsure of what the process is, and they get extremely defensive. It's a real bad situation for consultants to be in. However, it may narrow issues by determining those issues consultants agree upon and those issues they do not. If the manner that rulings are being prepared with less weight given to science evidence stays the same, then I would suggest you reserve hearing science-based evidence till later on. Hear science-based evidence only if a judge or jury cannot decide a matter based on what I as a layman would call an administrative basis. Precedent, essentially. The cynical public likes to call these technicalities. When precedent, process, procedure, or interpretation cannot be used to make a ruling, I suggest that an independent expert panel could provide that evidence in court. The expert panel would have reviewed the opposing party's expert reports pre-trial and would present a singular interpretation and opinion regarding the facts. No cross and no chief examination of the panel permitted.
Radical ideas, radical ideas. But I'm going to cut you off because really we'll make a few suggestions ourselves. But
Okay.
I'm really interested. We want to hear from you folks. So, Deep, in a perfect world, what would you do?
Well, Dan's right. I mean, battle of the experts, we've heard that all the time. I mean, one person says one thing, somebody says something else. But one thing that is solid is I've given courtroom testimony, and where a peer-reviewed report, a peer-reviewed standard, ASTM, government report, it's always been accepted every time. So maybe there's the solution, like Dan said, for the expert witnesses. Is, I give my report, somebody gives their report, it's reviewed by a blue panel committee. The Royal Society of Canada set up a blue panel committee headed up by Steve Rudy years ago to deal with energy issues here in the province. I mean, this is the province of Alberta. I mean, it wouldn't be that difficult for them to find some individuals to do that. And in the long run, it probably would save a lot of time and money. And I like the idea that it's been reviewed, peer-reviewed, no cross-examination. I think it'll solve a lot of problems.
I had one other suggestion I was going to tell you about. Because I think precedent creep is actually occurring, one of the things which is really radical is, and it would turn your world upside down, would be to eliminate the use of precedent in these kind of cases. And the reason you would do that is because you want to try things on a site-specific basis, essentially what we do with respect to risk assessment. I can't use precedent. Everything I do is based on the site-specific issues of the case, or in this case, the science that I do. So that's another option, but it would really turn your world upside down, because that's essentially how you make your livings and what you do and the way tradition has been. But we're getting to the point now where science has outstripped what's happening in the world. Think quantum physics, quantum mechanics, quantum entanglement. I can do something here in your body with a medicine, and at the exact same time I do it there, something else will happen to your chromosomes over here without any interconnection. So how does the legal profession deal with those?
My suggestions are more practical, because I'm an old government lawyer, and I know that any recommendation that requires money or someone else to do something is never going to happen. So what can we do? I think it starts with the investigation. There used to be expert investigators. There aren't any more. They're generalists. And this is an idea that Karen Hewitt of our office came up with, that for every file, an expert should be assigned so that the right evidence is collected, the right questions are asked in the early first 24 hours of the investigation. And we actually are working towards that, coming up with a roster. And the roster of experts is chosen in advance so that you're not scurrying around when the bad thing happens. So if the quality of the investigation is better, I think some of the fighting about science down the road may also go away. Second recommendation, and this is something we've done particularly on the Hub Oil file. This was essentially a joint investigation by defense and Crown experts. This requires a high degree of trust between you and your opposing counsel, and it requires a great deal of trust as between the two experts. But I will tell you just on the Hub Oil, the rules for engagement were set by the experts, not by the lawyers, and one of the primary rules is no lawyers invited. Third, this is a power that already exists in the court. The court has a power to call its own witnesses, or the court also has the power to appoint, you call it an amicus curiae. Of course, I think that's more popular and more done in the family law situations, and it's also done when you have unrepresented accused on like big major criminal trials. But there's nothing, from what I can see, that would prohibit the court from saying, I want my own guy. This is too hard for me to understand. I feel that the two opposing experts are fighting among themselves. I think it does take a measure of humility on the part of the court to say, I don't get it and I need help. So those are my suggestions. I'm really interested we're all interested in hearing yours.
And at this stage, if I could ask, if you have a question, the reason the cards are in front of you, would you please write down your question on the card for the benefit? We've got lots of people listening online, and just raise your hand, and then we'll come by, grab your card, and turn it over to the panelists to read out. So you can take a moment. We'll be doing this for all panels. Oh, just a comment? Well, go ahead, sure, with a comment, sure.
That's interesting, because you're right. I saw 1665. That's when they started doing it. And yet the courts, following the Goge inquiry into the Dr. Smith situation, the recommendation was not to go that route. But I think it's a good one.
Susan, just paraphrase a comment.
Just to make sure, this was, the comment from the crowd was the Admiralty courts have been using expert assessors since 1665. It worked then, it works now. Why don't we try it on something a little bit more extensive than Admiralty law? Is that a fair?
Yeah, except there is nothing more extensive than Admiralty.
Oh. Stand corrected. Okay.
Great, thanks. We have another question, and this is for Dan. If you can read out the question, Dan.
How important is plain language when explaining science-based concepts, mechanisms, and outcomes? It's imperative. Generally, want to say the judges, but in all cases it's not the judge, it could be a chairperson or whatever, has a limited science background. Some of them are engineering people who've gone into the law afterwards, extremely smart, extremely bright, but as I said before, one of my brothers has been a speechwriter for the politicians, and we argue over putting things in grade 6 language so that everybody can understand things. If you get things in such a language that it's just there, they get confused, and that's where I look on it and say, essentially, a judge or a chairperson then will fall back on what he knows, which is precedent.
We have a question for Susan.
Okay. What about training for judges? The Canadian Judicial Council publishes a science manual for judges. This is what they do in the States. This has been quite a movement in the American scope. There's been, I think, some real reluctance to incorporate that here in Canada. And it is a question of fairness. Do you want to have your trial determined, your fate determined by something somebody learned outside the courtroom? I think judges are concerned about that. And although that has been a suggestion, I think there's some real judicial reluctance to go down that route. The Goj inquiry, his suggestion was not that there be special education or training for judges, but that it start in law school, so that it's nothing new, that you learn about torts, you learn about scientific principles in law school.
Okay, we have another question here directed to the general panel. Many statutes, regulations refer to adverse effects and significant adverse effects. The question is, how does science assist in determining when an effect is scientifically adverse rather than just adverse?
This is my bugbear. I never, ever have won a case where the question is this a significant adverse effect based on science? I've won them when the judge can see the bad thing. He can see the dead duck. He can see the dead fish. One of my favorite judges said to me on a case many, many years ago, he said, "Is it too much to ask for one lousy dead fish?" You will do well if you have one lousy dead fish. But this is really the most this is the problem. Judges don't get it. They don't understand a causation model that is other than assault causing bodily harm in criminal court. If I punch Deeb and I directly cause an injury, they get it. They do not get the environmental long-term effects of the PCBs.
Like, I don't understand why the courts are having a problem with that either. Like Susan said, an adverse effect that you can relate to would be dead fish, dead birds, and we've done lots of experiments. But there are also instances that are a little bit more subtle where, toxic substance, a large amount has been released into a waterway, let's say like the Athabasca River. We have federal peer-reviewed processes to deal with that. I mean, Environment Canada has been developing these toxicity testing protocols for 30, 40 years. Every year I get another update from them. So these are well-established procedures that basically show that there is an adverse effect to fish or whatever you're testing. And of course, the chemistry is solid. I mean, a lot of the labs are credited. They do know almost to the standard of forensic labs, are very close to it. So I really have a hard time understanding why the courts have a difficulty in accepting that. To me, it's black and white. I mean, you can take pictures of a pail where the substance is in there and see all the dead fish. I mean, maybe that's what it takes.
My take's about 180 degrees different. And I'll give you the thought process why. Number one, environmental consultants can't practice the law. So we can't make that decision. And if you get an environmental consultant that's telling you he's got a reporting obligation or there's an adverse effect, you might as well drop him from your file or severely admonish him, and hopefully he hasn't put it in writing already. Adverse effect is so strange and so compelling a thought. Really the only guidance that I have in my jurisdiction is if there's an immediate risk to human health or the environment or an off-site. Those are the two situations that we might consider potential in telling our client he should potentially speak to legal counsel, or he should speak to legal counsel. But that's as far as I'll take it. The Fly Rock incident in Ontario, I never would have called that an adverse effect. I mean, for me to make that decision was, when I read it, I was floored.
We have a question from the floor. What about specialized courts? And the person making this comment says, Australia has a specialized land, water, and environment court where the judges build up expertise, and so does Bangladesh, strangely enough. So there are other jurisdictions that have, I think they call them science courts. And again, that is something that has been talked about here in Canada. But I'll borrow Judge Fradsham's answer to this question. I think he's one of the cleverest guys I know. And his position is, you cannot be an expert in everything. So even if you have specialized courts, they're not going to be experts in tributyltin oxide or fires or all the host of various things. He said, if you want an expert, shouldn't it be an expert in a guy who's good at telling who's lying and who's telling the truth? That's his answer. So I see there's some real value in it, but I think this is a judiciary that is not going to be open to that concept. Again, what did I say? Stuff that costs money and other people have to do? Not going to happen.
We have another question from Laura. Can you please comment on the process of preparing your expert report or testimony? What could lawyers do better, more to help their own experts? When I prepare a report, I mean, no report is the same. It all depends on the circumstances. It all depends on the discussion with the lawyers that I'm dealing with, whether it's defense or whether it's the prosecution. And usually we try and tell a story as simply as we can, and we use visual processes as much as we can. But I mean, this is an excellent question. I've been in court countless times, very complicated cases, where I beg to meet with the attorney and I say, we need to discuss this, and it never happens. You just show up on the stand. And I'll tell you, it's a disaster. It's an absolute disaster. And the reason that happens is I think that the attorney, whether they're working for the defense or the prosecution, underestimates really what's involved. It's not cut and dry by any means, like Dan said. And we've had the best cases that I've dealt with is where we've had lots of communication with the lawyers. In a lot of cases, we've sat hours and hours after a case discussing on what the opposition might come up with. Sometimes we've done that with a panel. And the results have been phenomenal, absolutely phenomenal. Trial went smoothly, went quickly, things got done. So yeah, you need to spend time with your experts, but more importantly, you need to tell them what's going on. We need to know how important is this evidence? Where do we fit in to this whole thing? Why are we here? And oftentimes that just doesn't happen, but it needs to.
The two things that I'll say are the most effective counsel I've worked with provide me with very succinct, very well-written questions in their instructions at the beginning to scope what the evidence I'm going to present is around, and presumably those speak to facts, but also the case, where the points of the case are going. Second, I really find it helpful when counsel provides me with the claims and with the pleadings, so I can understand what the basis of the case actually are. So I'm thinking about those things at the same time as I'm doing my evidence, but there's a bit of an issue there, and you all would recognize it with the impartiality of your experts. Form 53 in Ontario, I'm not sure what it is in other provinces. My duty is to the court, not to a case. So you have to be very careful in those kind of situations, and I only will point it out. Jennifer, I see you there, one of the Ontario lawyers. The direction from the Ontario Bar Association right now is up in the air with respect to how much interaction you can actually have with council and how much they can have input into your expert reports. And I understand the benchers have gone back to seek clarification on what the ruling is for council as to how much they can actually even speak to us. But give us those things and you'll get a better product.
Picking up on Dan's comments, one final question we have time for before the break. And the question is, you speak of importance of loyalty to court over advocacy by expert and attacks on credibility in subsequent cases. To what degree do we fail you by not explaining the outcome so you can defend your credibility the next time?
It's that there is no mechanism to defend your credibility. It doesn't exist. So that's kind of a problem. And if it's an unfair assessment because this judge liked the defense expert more than he liked yours, and that is going to hurt you in future cases, you know, again, we have some wonderful, wonderful judges. But I can tell you, every once in a while get a comment from one after the case is long dead to say, well, I preferred the expert for this side because he was easier. How does that make the witness who was the expert, who recognized the sophistication of the issue, how does that make him feel? So there currently is no mechanism, and I think that's a huge problem.
Thank you. We'll turn it over to Sarah.
Okay, we're going to wrap up. Thank you so much to this panel. We're going to have a whole morning of expert evidence, so this and your questions can continue. So, but a big round of applause for this panel.